Good evening, everybody. So, yesterday, good evening to you. Yesterday, we were discussing the specific field effect, and I also gave the history as to how the specific field effect came into play, and also what was the previous position and how equity stepped in. And I also gave an analogy that in India we don't have separate law of equity, but it is incorporated in various enactments. And one of the enactments in which equity was incorporated is a specific field effect. Here, it said all agreements which are entered into between the parties has to be specifically enforced. And the chapter which provides for specific performance is section 10 to section 24. Let us go section by section. Here, in 2018, an amendment was brought to section 10 of the Specific Relief Act. Please remember, I told you also, the remedy of specific performance is not available to you as a matter of right, and it's a question of discretion. And the word that is used, if you see section 10, earlier to the amendment, the word that was used is all agreements may be specifically enforced. But they found to give an impetus to the legal regime and also to see that the agreements are properly enforced, and there must be a methodology through which the agreements are enforced. People don't enter into an agreement just for fun's sake. Both the parties desire that they should not be violated or it should not be breached. So that is the reason why in 2018 the parliament felt that an amendment has to be brought to section 10. And the only amendment is the word may has been replaced or substituted by the word shall. Please, hello. Please mute, please. Here, as far as the amendment is concerned, please kindly note this amendment, please. So in 2018, an amending act was brought where section 10 was amended. The word may has been substituted by the word shall. That means that is to give impetus to agreements, to give impetus to contracts, to give impetus to the enforceability, and to remove the discretion from the court. This word may has been replaced or substituted by the word shall. That means no longer it is a discretionary remedy. Kindly make a note that today, as on today, section 10, the word shall is used. Shall is mandatory. The question of no discretion is left to the court in enforcing a contract. The earlier cases discussed by the Supreme Court was a case of Santoshamma versus Sarala and another. Here, and another case was Narendra Hirawat versus Sholay Media Entertainment Limited. That is, here they say, old act, they were to interpret the new amendment that has come to section 10 in 2018. The Supreme Court clearly set right all the contradictory judgments of the various high courts and set it at right and said the amendment means the word that is shall. All agreements respecting immovable property shall be enforced. Shall means it's mandatory, no question of any discretion. Here, one thing you have to remember is that is, it was also discussed what is the exact meaning of determinability. Determinability. Of course, the word determinability has not been explained in the act. Only thing is, if you look into the Webster dictionary, the meaning that is given is contract which can be terminated irrespective of the conditions for conditions for ultimate would be a terminable contract. What do you mean by terminable contract? A contract which can be terminated irrespective of the conditions for termination, would be a terminable contract. Terminable, the word terminable and determinable are two different things. What do you mean by terminable? Terminable is by implication, it can, by usage or by constructive notice, it can be terminated or it can be put to an end. That is, it is said, irrespective of the conditions for termination, would be a terminable contract. That is, whatever conditions may be imposed in the contract, irrespective of that, it can be terminated. That is, it can be put to an end. But as far as the Webster's dictionary is concerned, the word determinability is defined as liable to be terminated. Here, what do you mean by liable to be terminated? Determinability. Suppose some conditions are imposed whereby those conditions are not followed or implemented, then in that case the contract can be terminated. That's what Webster's dictionary says. And the other dictionary say that contract which can be terminated irrespective of the conditions for termination would be a terminable contract. That is, suppose let us say various conditions are there. Suppose let us say the vendor agrees to apply for urban land ceiling. Number two, he agrees to get the land surveyed. Number three, he agrees to get the land localized and fixation of boundaries. Four, he also agrees and undertakes to apply for necessary clearances under the various laws. But in that case, irrespective of the conditions, suppose certain conditions are imposed which determines the contract. For example, suppose you say the balance of the sale consideration has to be paid on or before a particular date, or 3 years period has already elapsed. Time has been fixed for performance. You don't do it, then the contract gets automatically determined. But again, what I want to repeat is the implications of amendment to Section 10 by the Amending Act of 2018 clearly says the word discretionary has been removed, taken away from the discretion, taken away from the powers of the court, and the word may, the only that word has been replaced with the word shall. There's a lot of difference between may and shall. I think you understand. May means discretion. It may or may not, that is, it can be granted, it cannot be granted. But now, all contracts relating to immovable property, whenever there is an agreement, shall be specifically enforced. That means the discretion of the court is removed by the Amending Act of 2018. And this has been done, the object of which it has been done is to give impetus, to give encouragement to the legal regime, and to prevent people from committing a breach of contract and also taking advantage of the loopholes and the lacuna in the law. The word may has been removed and shall has been introduced. And this has been upheld by the Supreme Court in the various cases before it. So they say no more discretion is available to the courts, and the court shall, whenever an agreement is propounded, the agreement shall be enforced. So please remember, now the question of discretion under section does not arise. So that I wanted to highlight, sir. Now we go further. Then there are certain instances where a specific performance cannot be granted. I'm sorry. Next section is who can file a suit for enforcement of a contract. Before going into it, you know that there is a law in contracts called contract binds only previous to the contract. A stranger to a contract cannot sue under contract. But Section 11 says a contract inures to the benefit of not only the person who is a party to the proceedings, party to the contract, but also his legal representatives, his assignees in interest, his transferees in interest, or his executors also can file a suit for enforcement of the contract. So, in other words, the law of privity of contract is given a go by. So, either the son or the daughter, when the deceased is no more, or his assignee's interest, the contract which has been assigned to a particular person, or the transferees in interest, where the benefits of the contract has been transferred to another person, or executors, a person who has to implement the will of the deceased is called an executor. All of them can file a suit, and they are competent to file a suit under the provisions of Section 11, and the doctrine of privity of contract does not apply. Then we go into the instances where specific performance cannot be granted. Here, specific performance either to was uh, only a discretionary remedy. But now, after the amending Act of 2018, it has become a matter of right. But there are certain contracts which cannot be enforced. For example, suppose let us say the discharge of contracts under Section 56 of the Contracts Act. It is said whenever the contract becomes impossible of performance because of the subsequent act of the executive or the government, the contract cannot be enforced. For example, if you take the liquor trade, hitherto it was lawful to conduct a business in liquor, but subsequently the government changes its policy and introduces prohibition whereby sale of liquor is banned or is prohibited. But at the time when the contract is made, it was perfectly lawful. But subsequently, the contract has been rendered unlawful because by the act of the government by the change of policy. Then, in that particular case, the contract gets frustrated, that is, it cannot be performed. I'll take another example, sir, where suppose let us say the property which is agreed to be sold is required for a public purpose to construct a hospital or to construct for a benefit of the people, it is sought to be acquired. Acquisition proceedings already take place, or in road widening, the a certain piece of the property has been acquired by the government. Then, in that case, the contract cannot be performed for the whole property. It can be performed only to the extent of the property which remains. Then we say that the contract becomes frustrated. Then the next contingency would arise when the property is destroyed by fire or natural causes. Then, in that case, the contract cannot be performed and specific performance cannot be ordered. Then, if the contract is vague and imaginary without clarity, such a type of contract also cannot be enforced. Then, the next contingency is suppose the performance of a contract depends upon the specialized skill of a person. For example, sir, we are after all mortals. We are not going to be healthy throughout our life. Sometimes we have a physical disability or a mental disability, or there is a malignancy as far as your parts of the body is concerned. Then naturally, sir, no one would go to a surgeon who is only a novice or who is only a beginner. You try to go to an expert. When you go to an expert, you enter into a contract with him that he shall perform the operation on you and then take the necessary fees and do it. But suppose, let us say later on, when the date fixed for the operation is arrives, the surgeon, who is a reputed surgeon, suffers from mental or physical disability, he is unable to move and is paralyzed. Can he perform the contract? No. But in that case, if you agree to take the performance from his junior or any other assistant to whom you are referred, and then you say, sir, I'm not bothered whether the senior does it or junior does it, let him do it. Then in that case, you cannot complain and file a suit for specific performance that the surgeon has committed a breach of contract by not performing the operation as agreed upon under the contract. This also, I think, perhaps most of you have been legal people. Normally, here, of course, unfortunately, the myth among the clients today is any person who has got gray hairs, any person who looks old, any person who comes with ragged clothes is deemed to be a senior, and then he knows everything. And then he wants his case to be argued only by the senior. But the senior has got about 15 juniors with him to whom different works are assigned. And let us say on the appointed day when he has to conduct the arguments, he suffers from mental or physical disability. Then in that case, can he perform the contract, sir? No. Then what is the position, sir? Contract can be avoided. Even if it can be avoided, suppose you accept performance by a junior who is quite capable and he acts under the supervision of a senior, then you cannot complain of breach of contract. That is one of the sections, sir. Then going further, sir, section 14 says that suppose under a contract, yes, Sir, రేపు కలుద్దాం కృష్ణ గారు రేపు కలుస్తాం సార్ సెకండ్ వర్క్ రేపు సెకండ్ వర్క్ కలుస్తాం టైం లేదు. Suppose under contract you accept performance from a junior and the senior is unable to do it. I told you that the contract gets frustrated, and then the question is because a specific performance is not available. Suppose the contract contains all minute and vague details which is incapable of being performed, then in that case, such a specific performance cannot be granted in those circumstances. I told you also that specific performance is based on two maxims. One who comes to equity must come with clean hands. One who seeks equity must do equity. Suppose, let us say, you don't have a penny in your pocket, or you do not disclose all the facts, and you are the wrongdoer, not the other person. And then these are all things which you might or ought to have disclosed, which you have not done. Then, or you are not prepared to perform your part of the contract, then no specific performance can be granted. Then sometimes what happens is, um I think you are aware of Section 73 and 74 of the Contracts Act, which says, which talks about liquidated damages and penalty. Suppose, let us say, a genuine pre-estimate of the amount that is liable to be paid in case of breach or violation of the contract can only be allowed by the court. But if suppose, let us say, the contracted sum or the contracted amount is 75 lakhs, but you stipulate in the contract that in case of breach or violation, the purchaser is liable to pay double the amount. Can such a clause be implemented, sir? It cannot be done. Why? Because a penalty can never be enforced by the court. Only a genuine pre-estimate of the loss which is likely to be suffered by a person, which the parties conclude is a genuine pre-estimate of the loss, only such type of contracts can be enforced. Then normally a clause also is added in case the amount is not paid within the stipulated date, the advance and earnest money which is paid by the purchaser to the seller shall stand forfeited. Please remember there is a doctrine of what is called unjust enrichment. When you want to avoid a contract and you don't want to perform the contract and you don't want to sell the property to the opposite side, the monies which are had and received has to be restored back to the opposite side. Then in the Contracts Act, there are two sections which deal with novation, novation, alteration, rescission, and modification of a contract. Suppose, let us say, during the subsistence of the earlier agreement, a supplementary agreement is drafted and comes into the picture. And let us say the old contract, for all practical purposes, is extinguished. New conditions and new stipulations are incorporated. Only the new contract has to be performed. That is where we call it as a novatio contract has come into existence, or a new contract has replaced the old contract. Then, in that case, the contract has to be performed only as per the new contract, and the old contract comes to an end. So then we got what is called alteration. Alteration means at the time when we enter into a contract, I agreed to sell you about 10 acres. Let us say subsequently, because of change of circumstances, I am able to sell only 8 acres. Then in that case, the original contract is again modified, altered, and instead of mentioning it as 10 acres, will be mentioned as 8 acres. Then modification. Suppose, let us say, the original contract, the schedule is not correctly mentioned, or the description is not properly given, or the extent of land is not properly given, or the land which is in your possession or within your disposing state is not available. Then, in that case, the contract is altered and then changed into a new scenario. Suppose, let us say, I got about 10 Madigis. I agree only to sell 3 Madigis, but 7 Madigis I don't want to sell. Suppose the original contract is vague and imaginary and does not really speak about the intention of the parties, then the original contract can be altered. So in all these circumstances, the question is the specific performance will not be allowed. But one thing you please remember, in case the contract is avoided or fails due to some reason, The monies had and received has to be restored back to the opposite side. But please remember, this section 10 also goes along with section 22. In the Civil Procedure Code, I think in Order 1, you have got alternative and inconsistent pleas, which might or ought to have been taken. If not taken, is deemed to be waived. Here, what you have to do under section, when you file a suit for specific performance, by any chance, if specific performance cannot be granted, the alternative relief should be refund of the earnest and earnest money which has been paid, whatever amount it may be, with interest at 24% per annum. So this alternate relief you have to always claim, whether you get it or not, when specific performance is given to you or not, it is said that alternative relief has to be specifically pleaded. That's what section 22 says. Then these are the basics as far as specific performance is concerned. Just a minute, sir.
అమ్మా ఇప్పుడు 3 కిలోలు 4 కిలోలు తెచ్చాను నీ ఇష్టం వాడుకో
ప్లీజ్ మ్యూట్ ప్లీజ్
యా వాళ్ళు 1వ తారీఖే నీ అమ్మ
He is not wearing today. ये क्या मेरे बोलो डिपार्टमेंट क्या
Section 15 says, please mute, please. Who may, please, it causes disturbance, please, Mr. Muralidhar. Who may obtain specific performance? I have already discussed, that is section 15. Then we go to, sir, please mute, please.
సాయంత్రం చెప్పాను నాకు నేను కోచ్ అయిపోతాడు మీరు గ్రూప్ లో పెట్టాడు కదండి యూఆర్ గివెన్ ద ప్రొఫైల్స్ ఆఫ్ మన క్లాప్ డాక్టర్ స్టోర్ लोग एडमिट कर रहे हो यस फेलिसिटेटेड हमारे और बोले ना
please don't cause disturbance, please.
रेस्पॉन्स अपने इफेक्टिव 8-9 आ रहे हैं 5-6 डॉक्टर
please don't disturb, sir.
9 आ रहे हैं मैं एक काम करता हूं
hello Mr. Muralidhar, please. Mr. Muralidhar, please bear with me. Here we come to section 17, which says contract to sell or let property by one who has no title but not specifically enforceable. You have got a maxim called nemo dat quod non habet. No man can pass a better title than what he himself has. Here it is said, suppose let us say that is Mr. Muralidhar, at this rate I cannot continue, please. Hello, please. Ajay, don't you listen to what I am saying? Mr. Muralidhar Bala, please bear with me. Here, there is a maxim called nemo dat quod non habet. That means no man can pass a better title than what he himself has. Suppose, let us say, your vendor has no title at all, or he has no right to sell the property, or he has no right to alienate the property, or he has no right to execute an agreement of sale in your favor, or a person who enters into a lease with you has no right to lease out the property to you, or he is not the owner of the property, then in those cases it is said, when you know that he has no title, sell or let, that contract is not enforceable. That, Mr. Muralidhar Bala, please. I cannot continue the lecture at this rate. Please. Till you stop, I am not going to lecture, please. Mr. Muralidhar Bala.
Ask the admin to mute all, sir.
Mr. Muralidhar Bala, please.
Admin, at least remove the person who is unmuted.
Yes, yes, I'll remove him. I'll remove him. Sir, there doesn't seem to be any sense, sir. I'm sorry.
Please remove, right?
Mr. Muralidhar Bala, have you stopped? Please stop.
Sir, ask the admin to remove, sir.
Yes, sir.
Admin to remove it, sir.
Yes, sir. Because I'm not very much acquainted with that, sir. My colleague will come. I'll talk to you. 1 minute. What is this? Mr. Muralidhar Bala, don't you understand simple English?
26. 26, Shailaja madam. Sir, you have access to.
Just a minute, sir.
Please.
అరే వాడు ఎవరు మాట్లాడుతున్నాడు మురళీధర్ బాల అన్మ్యూట్ చేయండి. Yes, sir. Sir, section 17 is dependent on the maxim nemo dat quod non habet. No man can pass a better title than what he himself has. Suppose he tried to enter into a contract with a person who has no title or ownership or proprietorship or possession of the property, or he has no right to let out the property, then it is said, and you also know about it, then the question of, say, it is said the contract is not specifically enforceable. Believing you have a good title to the property cannot, at the time fixed for the parties of any by the court for the completion of the sale or letting, give the purchaser or lessee a title free from reasonable doubt. So what is important is nemo dat quod non habet says no man can pass a better title than what he himself has. But suppose you enter into a contract with a person who has no right at all, then in that case, whether it's a contract for sale or whether it's a contract for lease, it cannot be enforced. Then we go to section 18. Section 18 speaks about what is called non-enforcement except with variation, where a plaintiff seeks specific performance to which the defendant sets up a variation. The plaintiff cannot obtain the performance except with the variance to set up in the following cases, namely, where by fraud, mistake or fact or misrepresentation, the written contract is sought in its terms to effect different from what the parties agreed to or does not contain all the terms agreed to between the parties on the basis of which the defendant entered into the contract, where the object was to produce a certain legal result which the parties frame is not calculated to produce, where the parties have subsequently the execution of the contract varied its terms. Sometimes what happens is I change my mind at the time when we make the contract. I try to agree to sell for 5 madigis. Let us say later on I change my mind, and with mutual consent, both of us enter into a supplemental agreement whereby the contract is varied or modified to say only 2 madigis will be sold. Then in that case, specific performance will not be ordered unless the variation is implemented. So when the original contract is varied, when the original contract is modified, or if this happens due to fraud or what is called misrepresentation or whatever it is, then in that particular case, when the real intention of the parties is not depicted in the document, such a contract cannot be enforced. That is a provision of section 18. Then we pass on to section 19, please. 19 says relief against parties and persons claiming under them by subsequent title. It is said, except as otherwise provided, specific performance may be enforced against either party, any person claiming under the title, any person claiming under the title which, though prior to the contract and known to the plaintiff, might have been displaced by the defendant. And number 4 is where a company has entered into a contract and subsequently becomes amalgamated with another company, the new company which arises out of the amalgamation, when the promoters have before its incorporation entered into a contract for the purpose of the company and such contract is warranted by the terms of such incorporation. Here, this section is mostly concerned with companies. I think some of you have been in the corporate sector or have knowledge of the company law. Two companies can merge together and become one company. I think this is happening today, what is called disinvestment. Perhaps most of the companies today which are in doldrums are trying to merge with another company which is prosperous. Then in that particular case, two companies come together and form one company which is called an amalgamated company. But please remember, under the Companies Act, a company does not come into existence overnight. Certain preliminary work has to be done to bring the company into existence. Who are the persons who do the preliminary work? Normally, it is the promoters who do the spade work. They try to make a market survey, viability of the product which is going to be manufactured, or the profitability as far as the product is concerned. What are the markets which are available for the product which is going to be manufactured by the company? Who will be the prospective buyers in case that product is marketed or distributed? Then all these factors will be considered, and that's why they prepare what is called a project report. And when the project report is prepared, it is normally the promoters who do it. That is the initial people who initiate the business, initiate the program of forming a company. Then please remember, when they form a company or they want to form a company, they enter into preliminary contracts, pre-incorporation contracts with third parties, and also obtain contracts from those people with the specific understanding and promise that as and when the company comes into existence, they shall try to get those preliminary contracts ratified by the body. And naturally, the third parties also enter into a contract because believing the promoters who are the people responsible for the formation of the company. Then, in that case, the question is, when normally the promoters become the first directors of the company as and when the company is born. And these people at the meeting of the directors or meeting of the shareholders ratify all pre-incorporation contracts. Suppose, let us say, you as a person has entered into a contract with such a promoter. Then in that case, whatever contracts are entered into prior to the incorporation, prior to the company being born by the promoters for and on behalf of the company, or the equity share capital which has been raised by the company to form the capital, or the banks which have been approached for the purpose of grant of working capital arrangements, these promoters, whatever contracts are entered into during in the process of the company being born, they are all binding on the new company, because these promoters become the first directors and they have to honor all the pre-contracts. That means, suppose I enter into contract with the promoter before its incorporation, I can definitely bring an action against the company as and when it is born, saying that these are the contracts entered into by the promoters, and the promoters who become the directors are bound by such contracts. Then the second one is when the two companies merge together, then they become one company. It is called amalgamation. Amalgamation is when two companies merge together and become one entity. It is called an amalgamated company. And whatever contracts are entered into by the previous company before amalgamation, they are also bound. They are also binding on the amalgamated company as and when it comes into existence. That is, a suit can also be brought for the purpose of enforcing such a contract. Then, next one is where the company has accepted the contract and communicated its acceptance on the other party to the contract. Please remember, these promoters who enter into a pre-incorporation contract, as soon as the company is born, they become the directors, and then at the first available meeting, the pre-incorporation contracts are ratified.
Lighting.
And the pre-incorporation contracts are ratified by the directors at the first meeting. Then, in that case, the ratification or acceptance is communicated to the opposite side. In case there's a breach or in case there's a violation, the contract can be enforced. That's what Section 19 says. And if two companies come together and form one company.
Sir, going so slow.
Yes.
People are requesting me. You are going a bit fast. And on YouTube also, people are asking you a bit slow.
If two companies come together, form one company, then in the case, and a contract is entered into by the company which has merged with another company, the other company is bound. The amalgamated company becomes bound to honor such a contract. That is, I just visualize a situation. Section 19 deals with mostly companies. Here, suppose let us say, where a person claiming under him by a title arising subsequently to the contract except a transfer for value for was paid his money in good faith and without notice of the original contract. Here, Section 19 postulates that suppose there is a contract and let us say there is a pre-existing contract, then subsequently a new purchaser comes into play and a new agreement is executed in favor of the second purchaser. What is the duty of the first purchaser, sir? The first purchaser has to say, sir, I've already got a subsisting contract with me. An agreement has been entered into by the company with me. Please don't enter into any agreement because you are the second person. But he keeps quiet. And the other second purchaser, what he does is, he acts in good faith.
Sir, somewhat slow, sir.
Yes, sir. I again repeat, sir, Section 19 postulates where on the...
Voice should be bigger and a slow pace. And మీరు వెళ్ళే ఫాస్ట్ కి చాలా మందికి వెళ్ళదు. సో ఐ రిక్వెస్ట్ యూ టు గో స్లోలీ, క్లియర్గా చెప్పండి.
Section 19 postulates a situation where a person, any person claiming under law by a title arising subsequently to the contract except a transferee for value who has paid the money in good faith and without notice of the original contract. Here, it is said, on the day when I transfer the property or enter into an agreement, I had no title. But subsequently, I acquired title. And at that time, I entered into an agreement with you. Then subsequently, when I get title to the property or when I get a right to that property, I enter into a second agreement. And the person who is the second agreement holder acts in good faith and pays the consideration without notice of the original contract, then such a person can enforce the contract. Are you able to follow, please? Here, where on the date of contract, I had no title, I had no rights, I make an agreement, but subsequently, when I acquire title, I execute a second agreement, and the second agreement holder acts in good faith and also pays the consideration without notice of the original contract, then even though I may be the second purchaser, my rights are protected. Are you able to follow, please? On the date when I make the first agreement, I had no title, right?
Yes, sir.
Then subsequently, let us say, and I make an agreement in favor of A. Then subsequently, when I acquire title to that property, I have title. Then I execute an agreement of sale in favor of the second purchaser. And the second purchaser, he has no notice of the original contract. He has no notice that before the title is acquired, an agreement has been made. He acts in good faith, gives wide publicity, pays the consideration. Even though I may be the second agreement holder, I can enforce the contract. Is it clear to you, please? Yes? What are the conditions, sir? I must act in good faith. Then second one is, I must pay the consideration. Third one is, I must not have knowledge of the original contract. On the day when the contract is made, the first agreement, I had no rights, right? Agreed. Subsequently, I acquire rights over the property as a seller and I enter into a second agreement. And the second agreement holder acts in good faith, makes all inquiries possible, and makes all the wide publicity, and also gives a notice asking for objections. No one objects for it. I have no notice of the original contract, though I may be the second purchaser, my title is protected. Am I making myself clear to this? This is the first limb of section 19. That is a bona fide purchaser for value without notice. Is it, you can follow it, please. Yeah.
Yes, sir. Yes, sir.
Yes, sir. Next one is any person claiming under a title, even though prior to the contract and known to the plaintiff, might have been displaced by the defendant. What do you mean by that? Suppose, let us say, the earlier purchaser has not paid the balance of the sale consideration within the time frame, and his agreement has been revoked or cancelled by a notice given by the seller, and the seller subsequently executes a fresh agreement in favor of the second purchaser. Then the second purchaser gets precedence and he gets rights over the property. This is the second situation, sir. Third situation is here. I think you know the meaning of the word amalgamation. Amalgamation is where two companies get merged into one company. All the assets and liabilities,
Including shareholding, sir?
including shareholding, etc., gets transferred to the new company.
Sir,
Amalgamated.
Andhra Bank merging into UCO Bank.
Exactly. Union Bank has now within its umbrella the Corporation Bank, and the Andhra Bank is UCO Bank. Union Bank of India. Then other banks are also there. State Bank of India, you know.
Union Bank of India.
Yes, sir.
Sir, can I?
Yes.
Can I?
సార్ ఇప్పుడు యూనియన్ బ్యాంక్ ఆఫ్ ఇండియా కనుక ఒకవేళ కనుక మర్జ్ అయితే ఇఫ్ ఇన్ కేస్ గెటింగ్ మర్జ్డ్ సార్ మీకు ఓఎన్జీసీ కానీ రకరకాల వస్తున్నాయి ఇప్పుడు షేర్ హోల్డింగ్స్ బట్ గెట్ ట్రాన్స్ఫర్డ్ టు ద పర్టికులర్ నేమ్.
Yes, sir.
దిస్ ఈస్ ఆల్రెడీ డన్ ఇన్ ద సెబీ రూల్స్ లో ఉన్నాయి. When any emergency is taking place, SEBI will take care of it.
Yes, sir.
Now we are having the disinvestment policy also.
I am saying meaning of amalgamation.
Amalgamation
Merging of
is
one company into another
exactly
company.
merger.
Taking hold the rights of another company.
And
The merged company will give away its rights, and the
exactly.
merging company will take over its rights.
Exactly. It becomes one company.
Sir, your voice is inaudible.
Sir, when two companies
I have unmuted myself.
sir, when two companies unmute you. Yeah. When two companies come together, take over the assets, and the new company comes into existence, and the new company takes over the assets and liabilities and also the share capital or the shareholders, then in that case it is called a single entity called an amalgamated company.
For example, Kingfisher Airlines has taken over Deccan Airlines.
So many instances are happening today, because what they call it is foreign direct investment, then the question of government shredding its equity capital, and then private limited companies being turned into something else. So what I'm trying to tell you is, when two companies merge together and become one company, whatever contracts are entered into by the company which merges with another company and becomes one company, the amalgamated company becomes liable to honor all the contracts which are entered into by the previous company before at the time of leaving it and getting amalgamated. Is it true, please? So amalgamated company becomes responsible to honor all the commitments, and a suit for specific performance would lie against the amalgamated company. And so here the doctrine of privity of contract does not apply. Second instance is amalgamation. First one is bona fide, in good faith and without notice of the earlier contract. The third one is, sometimes a company is not born in a day, right? Preliminary contracts has to be entered into, a project report has to be prepared, the viability of the product has to be found out. Then who are the companies who are going to give you prospective orders has to be found out. Then which are the banks which are liable, which are going to give you working capital arrangement, that also to be explored. Then the staff has to be recruited. All this preliminary work, and the MOA, or what is called the Memorandum of Association, and Articles of Association, and the prospectus has to be prepared by the promoters. Then the necessary forms have to be submitted by the promoters to the ROC or the Registrar of Companies for incorporation. Then the incorporation certificate is obtained from the ROC or the Registrar of Companies. Then the preliminary contracts which are entered into by the promoters with third parties regarding the product which they are going to market. These products have to be the contract has to be strictly performed in order to instill confidence in the people who have entered into such a contract. That is the reason the promoters, as and when the company comes into existence, they are made the first directors of the board. And in the first meeting of the board of directors, they try to ratify all the acts, preliminary contracts which are entered into before incorporation. And the ratification or acceptance is communicated to the offer to the third party. Then acceptance of an offer is a lighted match to a train of gunpowder. That means once acceptance is made, it cannot be revoked. That is called Section 90. Is it clear to you, please? Please caution me when I'm going fast, please, because it is my habit. I'm sorry if I'm going a bit fast. Then here, Section 20 deals with the discretion part of the court to grant specific performance. Here, this object of this Section 20 is it corresponds to old Section 22 of the Specific Relief Act 1877. Court is not bound to grant the relief of specific performance merely because it is lawful to do so, but the discretion of the court is not arbitrary but sound and reasonable, guided by judicial principles and capable of correction by a court of appeal. This section is not exhaustive and does not deal with all possible pleas which may result in the dismissal of the suit claiming the relief of specific performance. But perhaps this section now, because of the amendment to Section 10, may become redundant. Why? Because the word may has been replaced or substituted by the word shall. By the Amending Act of 2018, Section 10 has been amended, whereby they say to promote the legal to promote or give an impetus to the legal regime and to see that the contracts which are made are honored and followed in the letter as well as the spirit. Section 10 has been amended, whereby the word may has now been removed, and whenever a suit has been brought for enforcing a contract, the court shall enforce the contract. That means no discretion is left in the court. Are you able to follow, please? Section 20 prior to the amendment may have had some relevance, but today Section 20 may not be applicable because Section 10 has been amended, where the discretionary powers of the court has now been taken away by the amendment. So, in other words, courts are bound or shall, or there is no other alternative than to enforce a contract as per the terms and conditions. Is it clear to you, please? So, discretion part of it has now been taken away by the Amending Act of 2018. Is it clear to you, please?
Yes, sir.
Yes. Now we go to Section 21. Here, Section 21. Section 21. Yes. Power to award compensation in certain cases. In a suit for specific performance, the plaintiff may also claim compensation for its breach, or in other words, in addition to substitution of such performance, if any, in such suit, the court decides that specific performance ought not to be granted, but there is a contract between the parties which has been broken by the defendant, and that the plaintiff is entitled compensation for that breach, which shall award him such compensation. If in any suit decides a specific performance ought to be granted, but that is not sufficient to satisfy. Here, sometimes what happens, sir, because of the breach, because of the violation, lot of mental pain and anguish is caused to the plaintiff. Apart from specific performance, the plaintiff is entitled to reasonable compensation by way of punishing the defendant for the breach which he has committed. So, Section 21 gives ample powers to the court to grant compensation also in addition to specific performance. Is it clear, please? So, in addition to specific performance, court may also grant damages by way of compensation. But I told you Section 73 and 74 of the Contracts Act speaks about liquidated damages and penalty. Suppose, let us say, the sale consideration under the contract is 75 lakhs. Because of the delay on the part of the vendor to execute the document, lot of difficulties arisen where the vendor suffers. Then the amount of strain or amount of stress to which he has been put, he has to be compensated. So for that, a genuine pre-estimate of the likely damage which might have been caused to the plaintiff can be awarded by the court under Section 21. I try to put it again, sir. Suppose, let us say, in addition to specific performance, suppose the defendant is guilty of non-performance or the plaintiff has been put to hardship and has been put to unnecessary expense, then in that case, for belated performance or delay in performance, compensation can also be awarded for the purpose of breach or violation committed by the defendant. Is it clear to you, please? Here in a suit, again I repeat, in a suit for specific performance, suppose the breach is on the side of the defendant or the seller, and the seller unnecessarily delays the matter, and the plaintiff is put to unnecessary expense and trouble, then in that case, court can also award compensation for belated performance. Is it clear to you, please? So, in addition to specific performance, even damages or compensation can be awarded under Section 21. But one thing is this, that we should not be exceed the sale consideration. Suppose the sale consideration is 75 lakhs. You cannot award 1 crore for the breach committed. It should be a genuine pre-estimate. It may be 10 lakhs, it may be 20 lakhs, it may be 30 lakhs. But the genuine pre-estimate of the loss that is caused to the plaintiff because of non-performance on the part of the defendant. Then, suppose the court finds the relief of specific performance cannot be granted due to any reason. Then instead of that, it can order for return of the advance and earnest money and also award compensation instead of performance. The first limb is, the question is, suppose the plaintiff is put to difficulties because of the violation or breach on the part of the defendant, the court, in addition to awarding specific performance, can also award damages or compensation. And that compensation is a genuine pre-estimate of the loss that is caused to the plaintiff. Second one is, suppose for any reason the court finds that specific performance cannot be ordered, then in that case, court orders the defendant to pay compensation in addition to the amounts which have already been paid. Is it clear to you, please? Then the third one is that if the determining the amount of compensation, the court shall be guided by the principles, and that's what I said. 73 of the Indian Contract Act. No compensation shall be awarded unless the plaintiff has claimed such. That's important. Here, please remember, previously in equity, under the doctrine of unjust enrichment, it was said, court, irrespective of whether you claim or not, court can grant compensation, or court can order for return of the advance money with interest. But now, unless you ask for compensation or refund of the money, court has no power to grant compensation. So that's why it is based on Order 6, Rule 2, which says plead and then prove. And Order 1 also says alternative and inconsistent pleas also shall be taken and can be taken. And unless you ask for that, court is not bound to grant. That's what 21 says. Here, Section 22 goes further, it's an extension of Section 21, which says, notwithstanding anything, any person suing for the specific performance of the transfer of removed property may in appropriate case ask for possession or partition and separate possession of the property, any other relief in which he may be entitled, including the relief of refund of earnest money, a deposit paid or made to him in case it's claim for specific performance. Here, as far as section 22 is concerned, in a suit for specific performance, naturally, sir, no one will take a property with tenants. No one will take a property which is occupied by someone else. In a suit for specific performance, you can also ask for possession under section 22. Is it clear to you, please? Possession of the property, actual possession, physical possession, symbolic possession, or constructive possession, or actual delivery of possession. But you can also ask for partition. Why? What partition, sir? Suppose, let us say, your vendor is only entitled for 1/4 share, and what you have purchased is 1/4 share of your vendor, or the undivided share of your vendor. And in that case, the other sharers are there. You can ask for partition and say, let that 1/4 portion be carved out and possession be given to him. So even a purchaser can ask for partition. Not the person who is a party to the suit, but even a person who has purchased it from one of the sharers can also ask for partition to be put into possession of the property to the extent of the share held by your vendor. You can also ask for possession. That is, you can ask for possession means to the extent of the share which your vendor had, you can ask for possession of that property. Or if the entire property is sold to you, then you can ask for possession of that property. But suppose, let us say, the other sharers are there, you can ask for partition and say, let my 1/4 share of my vendor be carved out of the property and possession of that 1/4 share be given to me. And next one is, you can also ask for refund of earnest money. Whatever you have paid, if the specific performance is refused, no relief is granted to you, whatever money you have paid to your vendor, you have got a right of getting refund of that money with interest. Those specific performance may not be granted. Then we go to here. Suppose, let us say, uh, suppose a contract is not specifically enforceable for due to any reason whatsoever. But in the contract itself, it is mentioned that in case of breach, in case of violation, in case of going contrary to the agreement, a sum of money shall be paid as liquidated damages. That is a genuine pre-estimate of the loss that is caused to the person who does not get the benefit of the contract. For example, suppose I agree to sell a property for 20 lakhs and there is no harm in my claiming 5 lakhs or 10 lakhs towards liquidated damages because it is lesser than the amount which is agreed to be paid and taken. But if it's going to be 40 lakhs, double the amount, it will not be enforced. Only a genuine pre-estimate of the loss or compensation or when specific performance cannot be ordered, that amount, only liquidated damages can be awarded, but the court will not enforce penalty. Is this position clear to you, please? Section 23 says a genuine pre-estimate of the loss that is likely to be caused to you in case of breach, and which is in the form of what is called genuine pre-estimate of the loss that is going to be caused to you, that will be awarded. Penalty will not be enforced. That's what section 23 says. Am I making myself clear to you, please? Then we go to the last section of specific relief. Specific performances. Bar in a suit for compensation for breach after dismissal of the suit for specific performance. Once the suit is heard, it is disposed of on merits after the respective evidences are laid on both sides and the findings are against you. Court is not going to grant you specific performance. Your suit is dismissed. Subsequently, you cannot file another suit asking for compensation for breach of contract. Am I making myself clear to you, please? Suppose your suit is disallowed, your suit is dismissed for specific performance, even you have not pleaded alternative relief, and court dismisses the suit, a subsequent suit cannot be brought for claiming damages or claiming compensation. That's what 24 says. Is it clear to you, please? Suppose your suit for specific performance is dismissed for any reason on merits, and you do not ask for alternative relief, or let us say the alternate relief also is disallowed, then you cannot bring another suit claiming damages or compensation from the other side. That's what section 24 says. Is it clear to you, please?
Yes, sir.
No. The Here, the provisions of this chapter as to content shall apply to the awards to which the Arbitration Act does not apply and to directions in a will or codicil to execute a particular settlement. Here, first of all, what do you mean by a will? Will means a testament executed by a person settling his properties in favor of the beneficiaries or the legatees as they are called. Then codicil. What do you mean by codicil? In the original will, suppose let us say some properties have got missed. Then in the supplementary document, in addition to the will, codicil is executed, whereby certain properties which have got missed will be mentioned in the codicil. Are you able to follow this? Will is a document which is, please remember, will is a controversial document which comes into existence after the demise of an individual. Codicil is one where, in addition to the will, certain properties have got missed in the original will and they have been supplemented and mentioned in the supplementary document. Both of them go together. Here, for the validity of a will, I think you know that the will is a controversial document which does not come into effect immediately, but it is postponed till the death of the executant. And the conditions or the essentials of a will, you know, the question is the property which is bequeathed or the property which is settled must be within the disposing capacity of the testator in case he is a male, testatrix in case she is a female, and then it has to be compulsorily attested by two witnesses. Two witnesses who see the executant sign and they identify the signature of the executant, and after the executant or the testator signs, they countersign the document in proof of having witnessed the signature. And they are the people who are acquainted with the handwriting of the testator or who are acquainted with the signature of the testator or the testatrix as the case may be, and they identify the signature and say that in our presence the person signed, we identify his signature and we countersigned it as having witnessed his signature. This is a will. Even the codicil is the same. But as far as Pardanishin ladies are concerned, as far as Muslims are concerned, a Muslim lady does not come outside. She remains behind the parda. The document is read out. Document is explained in the Urdu because she does not know English. And it is explained, every word, every sentence is explained to her. And her acceptance is taken whether the will has been drafted as per our instructions. Then when she says, yes, I agree, I acknowledge that it is my will and it is my desire. Then in that case, the testatrix signs the document behind the parda. She is identified by the persons who are the relatives, and the attestors countersign the document in witness of having read out the document, explained the document in their presence, and this is how a will is proved or established. But whatever, suppose you say arbitration. In an arbitration award, suppose some property is given to you under the award and it has become a rule of the court, then there is a contract regarding that particular property. This award to which your vendor got title to the property can also be enforced by suit for specific purpose. Am I making myself clear to you, please? Anything which comes by arbitration award or anything that comes to a will or any settlement which comes to a particular document can also be implemented and you can get title and agreements can be made and they can be enforced. That is the last section as far as specific purpose. Yes.
In the interaction section.
Yes. Now we come to the question now. Any questions, please? Yes.
Sir, namaste.
Namaste.
Sir, section 24 ప్రకారం సూట్ డిస్మిస్ అయింది అనుకోండి సార్.
Yes, sir.
అక్కడ ఆల్టర్నేట్ రిలీఫ్ కూడా మనం అడగలేదు, సూట్ డిస్మిస్ అయింది. ఎనీ అనదర్స్ alternate remedy for us, sir?
Suppose alternate remedy you have not asked, then in that case you cannot file a fresh suit asking for that alternative relief. Am I making myself clear to you, please? That's why the previous sections if you have seen, alternate relief has to be necessarily claimed. Even if your suit is dismissed, court can grant alternative relief. But if you don't read it, later on you cannot file a fresh suit. It's an absolute bar. Either for breach or either for violation or for asking for compensation. A subsequent suit does not put it that way. I mean, pardon?
By mistake అడగలేదు అనుకోండి సార్.
No question of mistake. Then your section 11(4) applies, which says all grounds of attack and defense which might or ought to have been taken, if not taken, is deemed to be waived. That's what section 11(4) of the Civil Procedure Code says. That is constructive res judicata. Or even you can go back on what is called Order 2, Rule 2, splitting of claims. That means you ask for specific performance one day, later on you ask for compensation. That cannot be done. If your suit for specific performance is dismissed for any reason, a fresh suit for compensation does not arise. That's a known position of law.
Okay.
Right?
Right, sir.
Sir, in what cases stay petitions, stay orders take place, sir?
See, what are you trying to ask? Stay petitions for what purpose? Yes, please clarify your question, please. You said stay petition. Stay petition for what?
Yesterday topic, sir. They wanted to ask, then session was closed.
Suppose you want to ask for stay. Suppose regarding that property, there is a comprehensive suit filed in a superior court questioning the title of your vendor, and it is pending adjudication. It has not yet been decided. Your subsequent suit for specific performance when you are the purchaser shall stand, stayed, or kept in suspended animation till that comprehensive suit is disposed of. That means stay means things stand where they are. They are kept in suspended animation. Am I making myself clear to you, please? That is, the other suit should be pending in a superior court, and the question of title of your vendor should be disputed in that, and your title of your vendor has not been declared by the superior court. Till such time it is declared, your suit for specific performance will be kept in suspended animation. Am I making myself clear to you, gentlemen?
Yes, sir.
Next, sir.
Sir, I am Rampa, sir.
Yes, please, go ahead.
Agreement of sale breach by seller, sir.
Yes.
Seller sold the property to another person.
Right.
Two agreements have been done. One is no essence of date, and other one is within 40. One agreement is no essence of date.
Right.
Ready for payment by Wendy.
Right.
Other one is within 45 days Wendy to be ready.
Yeah.
Make the money for execution of sale.
Right.
So seller sold the property to
a second
another
person. Right.
So what is the relief? Can I ask?
See, when you say there is a
specific.
Yes, sir.
Specific
when you say you have to first prove that there is an executory contract, number one, there is an offer, there is acceptance, all the ingredients are present. Third one is you will have to say that the prior agreement or whatever it is has not been disclosed to you, and you have made all inquiries and also made a publication calling for objections. You have acted in good faith without knowledge of the earlier contract. You have paid the consideration. When you plead all those things, even though your earlier contract may be there, suppose the earlier purchaser or the purchaser was entered into an agreement does not caution you, then you get precedence. That is what is called doctrine of priorities. When I come to transfer of property, I shall try to clarify that, please.
Okay, sir.
Next, please.
సార్ రేపు పర్సనల్ గా అపాయింట్మెంట్ కావాలి సార్ మీది.
ఏదండి
సార్ నేను గుప్తా ఫ్రమ్ కర్నూలు సార్.
సార్ ప్లీజ్ టెల్ మీ సార్.
సార్ మీ అపాయింట్మెంట్ అడిగాను నేను.
My
రేపు హైదరాబాద్ వస్తున్నాను సార్ నేను.
Yeah, my admin will give you, sir. You can contact Mr. Kalyan. He'll give you the phone number also.
You have a phone number the same, sir. నా ఫోన్ నెంబర్ అందులో రాసి
DRP Gupta.
సార్ సార్ నేను వాట్సాప్ లో పోస్ట్ చేశాను సార్ ఆల్రెడీ. రేపు ఈవినింగ్ టైం అడిగాను.
Evening 5 o'clock.
I send you Gupta garu, just check the number, sir.
ఓకే సార్.
WhatsApp chat box లో పంపించండి చూడండి.
షూర్.
Next, sir.
Sir, good evening, sir.
Good evening, Mr. Prasad Rao.
Small clarification. In the case of will,
Yes.
So if there is a case like the testator, after executing the will deed, has passed away,
Right.
and that document was witnessed by 2 witnesses.
Right.
So unfortunately, both the witnesses also passed away due to age or whatever factor.
Right.
In that case, how does
In that
the
case, how
deciding
you
authority-
prove a will is any other
Yes, sir.
person who is acquainted with the signature, handwriting, or the style of writing, or who is acquainted with that particular testator or the attestors also can come and depose saying that, sir, we are acquainted with the signature. We have got correspondence to show that he was corresponding with us, and then it is a signature of so and so. That is one way. Then there is another thing called Section 73 of the Evidence Act. I'm talking about the old Evidence Act, which says that the judge herself or himself can examine the documents and compare the signatures and come to the conclusion whether it has been executed by the person concerned. These are the 2 alternatives. Any person who is acquainted with the handwriting, with the signature, the style of writing can also be examined instead of the attestor in case both the attestors are dead. That is the reason, sir, for the safety sake, what we do is we take a young person as one of the attestors because he may outlive the testator. And normally people say when you take old people, it is more genuine. No, that is not the case. Take the signatures of young people who are going to live for some time at least. Am I making myself clear to you? Any person who is acquainted with the signature, any person who is acquainted with the style of writing, any person who has got acquaintance with the testator or the testatrix and they have friendly relations, they can be examined, sir. Or under Section 73 of the Evidence Act, the court can itself examine the signatures and come to a particular conclusion.
Thank you, sir.
Right, sir. Next, please.
Sir, this is Gangraj.
Yes, Anuradha Bakaraj. Yes, tell me, madam.
Yes. Suppose a person has made a will and after 3 months he purchases another property.
Right.
So instead of revoking the will, he makes a codicil.
Right.
Is it,
Right. Yes. The question is both the will as well as the codicil are enforceable because you visualize a situation when an agreement is made. In addition to it, and a supplementary agreement also is made. Both are enforceable, please. Though they may not be included in the original will.
Okay. And is it required that the witnesses should be the same or
not necessary? Not necessary.
Okay. Thank you, sir.
17 and 18.
No.
Geo. Geo.
Huh?
Shall you explain the contents of affidavit, sir?
Affidavit means it is an affirmation or sworn statement of facts made in first person. Who has knowledge of the facts or who has got in Telugu avagahana antaru chudandi adi, and he makes a statement where it is within his personal knowledge and testifies those facts and also gives it on oath. He is called a deponent, and that document which is executed is called an affidavit. And I told you also, as far as a Muslim is concerned, a Muslim does not take oath because it's against the Shariat. He only affirms and verifies the facts mentioned therein and only signs as an affirmant and affirms and signed before on whatever date it is. Affidavit is a sole statement of facts on oath is what is called an affidavit.
Sir, Sam.
Yes, Mr. Sam.
Sir, I want to know regarding this agreement to sell, sir. I've read a Supreme Court judgment which says agreement to sell doesn't confer to title.
Right.
So now
that is a case of Suraj Lam's case, 2004 or 2005 Supreme Court.
Yes, sir. Because I'm practicing in Maharashtra, sir.
Right.
Most of the properties here are agreement to sell
Right.
from way back, like from 50 years.
Right.
Okay.
Right.
Now few of the litigations arises right now
Because of escalation of prices.
Yes, sir. At that time, maybe the builder has not done the convenience.
Right, sir.
Yeah. Now the litigations are coming up. The both joint property holders
Right.
having the litigation.
Right.
Now, as per the specific relief act, declaration suit is a one remedy. Right. So, how do we go about this, sir? Like agreement to sell or something?
Agreement to sale is, suppose an earlier suit is pending. Let us visualize the situation. A comprehensive suit between two rival claimants claiming a share in the property. And you have entered into an agreement with one A, who is also a party to the suit for partition. Then in that case, subject to his rights being adjudicated, which you have acquired, undivided share which you have acquired, which has not been divided as and when that person gets the rights in the comprehensive suit, you can ask for partition and say, I will step into the shoes of that person. And whatever share that man had, it gets passed on to you. But if you file a suit for specific performance and the suit for partition is pending, you can get yourself implicated in the partition suit also, though you may not be a sharer, but he is a purchaser through one of the sharers. And whatever share your transferor gets, you also get the same share and you can get the property divided. You can ask for partition.
Okay,
I'm making myself clear to Mr. Sam.
Yes, clear, sir. The one who is in possession of the property, he has paid the loan.
Yes.
Another is maybe his sister. She gave a written letter to the bank that she has no, to avail the loan, she has no
objection.
Rights of the property. She has written a given commitment.
Right.
So now, what should I do for this, sir? I have a client now.
Are you for the sister? Are you for the sister or the brother?
I'm for sister, brother, sir. One who is in possession.
Who is that brother?
Yeah.
But yes, even if she writes such a document that she has no share, you cannot contract against or cannot execute the document against the statute. Even if she does it, she can resile from it under pressure. I've done it. So I want to resile from that. Are you able to follow, sir? And the question is, even if the claim is maintainable, it's only against the brother, only to the extent of his share.
So, but brother has the complete bank statement which he has repaid the loan, sir, 90% of the loan.
Right. Now you can also file that particular document which you have executed under pressure or undue influence have executed it. I want to avoid it. Though it may be a dishonest litigation, but you can do it.
Okay, sir. It's been 40 years, sir, now. He's in possession of the property.
Then you can ask for possession. Of course, for possession, only 12 years.
No, it's a joint property, no, sir. I mean, it's not, the relative.
Not divided or not partition. But now under 29A, the question is, as soon as a female child is born, she gets a vested right. She can also ask for partition at any time. That is 2020 Supreme Court. That is where Vinay Sharma versus some other party. That is it. The courts have held it is both retrospective and prospective, and the amendment can be enforced at any time. Vinay Sharma's case, Vinita Sharma's case, the Supreme Court has said it is both retrospective and prospective. As soon as a female child is born, she gets equal rights along with her brothers. Yes, please proceed.
Yeah, just the remedies for both brothers, and I'm asking for the both point of view, brother and sister. What are the remedies for both
sides? The remedies for the sister is to file a suit for declaration that for cancellation of that letter what she has given. And for the relief for the brother is to ask for declaration that because of that he has become the full owner of the property and he has discharged the loan in part performs of the document.
Okay. So according to your experience, sir, who is on merits of the case, sir?
Merits is as far as the brother is concerned, but sister has got equal rights, sir.
Okay, sir.
It's a debatable.
Thank you, sir.
It's a debatable question.
Okay. Thank you, sir.
Next person,
sir. Sir, explain about section 17 and 18, sir.
17?
17 and 18.
17 and 18.
17 and 18.
17 and 18 of Specific Relief Act. Specific Relief Act. 1 minute, sir. Is it specific relief, sir? Is it specific relief, sir? Yes, sir. Yes, sir. 17 deals with what is called contract to sell or rent property by one who has no title, not specifically enforceable. I told you there's a doctrine called nemo dat quaternam habet. In order to be competent to sell, you must have a present title. You must have a disposing capacity. You must acquire the property by any other mode, say it so and so, so and so. And if you have no title, your purchaser also does not get title. Or the agreement which you make with that person is unenforceable because you have no title. Suppose you want to make a contract of lease and on that day you don't have title, then in that case your lessee also does not get any title. That's what is an extension of the maxim nemo dat quaternam habet. Then section 18, what you have asked is, section 18 deals with non-enforcement except with variation. Suppose the original contract is varied, it is altered, or suppose let us say I've got 10 madigis, I intended to sell only 5 madigis, but by mistake, it has been mentioned as 5 extra madigis. Then in that case, I can vary the contract and alter it and say, I only agreed to sell 5 madigis and not 10 madigis. That is, you vary the terms of the contract. I suppose, let us say, some other person also has got the rights to the property which you have not impeded. Then in that case, you can vary the terms of the contract by adding that person also. And in the schedule, you show the correct description by saying, sir, I have only 5 madigis and the word 10 madigis may be removed. Am I making myself clear to you, please?
Yes, sir. Thank you.
Next, please.
Anybody else? Can we write up the class for today?
Tomorrow we're going to go into
Good evening, sir.
we're going to go into sale of the
Sir, Jai Guru Datta, sir.
You see properly and ask questions, sir.
Yes.
Sir, happy evening, sir.
Hey, good evening, sir. Tell me, sir. Yes.
No, sir. Unka maatladamani chesaam, sir.
Thank you.
You can give me a call and you can talk to sir. This is the only questionnaire which we are trying to do.
Chala santosham.
Thank you. Any more questions?
Yeah, one last question from my side.
Yes.
Yes, sir. Go ahead.
Cheppandi.
Yes. So, sir, these days, especially in case of will, we see people executing first will, second will, or will getting revoked, or irrevocable will. Irrevocable will. I heard so many things. Can you shed some light on that?
There is nothing called irrevocable will, sir. Will is also called as a testament. Any number of wills you can execute. Only rule is that you can, the last will alone is enforceable and it cancels all the previous wills. And it comes into effect after the demise of an individual, and the will which has been executed before the death is normally enforceable. The original wills get eliminated.
And is there any foolproof procedure that you would advise?
So, as for the foolproof procedure is, you get it registered, though registration is not compulsory, but if you get it registered, it becomes a public document, and before the register also your thumb impressions are taken and your signatures are also taken in the books, so that with that you can always prove and establish the signature of the deceased. It is advisable to get it registered, though it's not necessary.
But after registration, is it possible to revoke?
You can do it. Before your lifetime, you can execute any number of wills. But if you have executed a registered document, the cancellation of that earlier will also should be by a registered document.
Okay, sir. Thank you.
Welcome.
Any more questions?
Any more questions?
Sir, good evening, sir. With regard to specific performance, rights of dependent at what point of time the defendant can deny his part of performance.
Sir,
Tomorrow, you please once
today
explain, sir.
I'll explain the topic again, but for your question, I'll answer. Suppose it is it's a personal service. I told you if a surgeon has agreed to perform the operation and he has taken money and physically or mentally is disabled, you cannot compel him to do it. Or if you are prepared to take performance from his juniors or some other doctor and his instructions, you cannot complain of any breach or violation. I'll explain to it again tomorrow.
Yes, please, sir. Rights of defendant, sir, in specific performance.
Rights of
This
defendant, you got discharge of contract, isn't it? Under the Contracts Act, like what is called fraud, coercion, undue influence, misrepresentation, mistake, unilateral and bilateral, then doctrine of frustration, then novation, alteration, modification, or rescission. Then these defenses, which are available under the law of contracts, can also be applicable to this particular specific.
Thank you, sir.
Welcome.
Small announcement from my end and from Dharmaliga. There's a class on sale of books tomorrow. So we will announce it as a group also. Sale of books will also be there.
Okay, sir.
Alright. Thank you. And I request everybody who is participating in the Zoom class, please mute yourself so that the class moves in a very smooth way. If any kind of questions you have, you are free to ask. And after that, we announce it as a section for questions. Please understand. Mentally taken. That's my sincere request.
Yes, sir. Yes, sir.
Thank you much.
Thank you, sir.
Thank you. See you tomorrow again. Bye-bye.
Thank you. Bye-bye.
Thank you.
Thank you.